In our previous videos, we talked about the incentives for precaution that various tort liability rules create. In this video, we will explore the incentives for activity levels under various liability rules. We will then compare and contrast administrative costs under various liability rules. Last, we will talk about some issues of fairness. Precaution is how careful you are as you do a dangerous activity. An activity level is how much of a dangerous activity you do. For example, if we are talking about swimming, examples of precaution could be a swimmer that checks the depth of the pool before diving, or a pool owner that makes sure that pool depths are marked and that life-saving equipment is easily accessible. The amount of time that the swimmer actually spends swimming is the activity level. When driving, precaution is obeying traffic laws and making sure you are not tired. Activity level would be the amount of time that you actually spend driving. The probability of an accident increases with a higher activity level, like it does with precaution. The big difference between activity level and precaution is that the activity level cannot be observed by the court. Since the activity level cannot be observed by the court, a legal standard for activity levels will not be set by the court. You will recall that legal rules that did not rely on a legal standard of precaution created incentives for unilateral precaution. Strict liability gave incentives to the injurer to take precaution but not the victim, and no liability gave the victim incentives to take precaution but not the injurer. To get incentives for bilateral precaution required a legal standard to be set that defined breach of duty. Under the four liability rules that set a legal standard that defined fault, both parties had incentives to take precaution. What we will see is that since a legal standard cannot be set for activity levels, under each of the tort liability rules, only one of the parties will have an incentive to limit activity levels. Consider the issue of drivers and pedestrians. Suppose we have a strict liability rule. This will require a driver to pay damages to make a pedestrian whole if there is an accident. For this reason, only the driver has incentives to take precaution. The driver will have incentives to drive the speed limit and obey other traffic rules. The pedestrian, on the other hand, does not. If he is failing to take precaution by dressing so that he can be easily seen and by obeying traffic laws and he is hit, as the plaintiff, the pedestrian will only have to establish harm and cause to be made whole. The driver can also decrease the probability of an accident by driving less, that is, by reducing the activity level. The fact she is held liable regardless of whether she is taking precaution if there is an accident gives her the incentive to reduce the amount she drives. The pedestrian, again, does not have incentives to reduce activity levels by walking less. This is because if harm and cause is established, he will be made whole by the driver in the event of an accident. Recall from our video on no liability that no liability gave the victim incentives to take precaution but gave the injurer no incentives to take precaution. This is because the injurer was not liable. The injurer would also not have any incentive to reduce activity level. A driver, for example, under no liability could drive as much as she wants and never worry about being held liable for an accident. Since all liability fell on the pedestrian, it is the pedestrian that has incentive to take precaution and also reduce the activity level by walking less. Now let's look at the incentives that both parties have under a rule of simple negligence. Under a rule of simple negligence, the victim has the burden of proof to show that the driver failed to meet a legal standard of precaution to be able to recover damages. That is, the plaintiff must show that there was harm, cause, and that the defendant breached duty. If the injurer does not breach duty, she does not have to worry about being held liable for the pedestrian's injuries. For this reason, if the driver always meets the legal standard of precaution, under a simple negligence rule, she will never be liable for an accident regardless of the amount she drives. So the driver has the incentive to meet the legal standard of precaution, but she does not have an incentive to limit activity levels. Once the driver meets the legal standard of precaution, simple negligence becomes no liability. And under no liability, the victim has incentives to take precaution and to limit activity levels. So under simple negligence, both parties have incentives to take precaution, but only the victim has the incentive to limit activity levels. I think the simplest way to figure out who has incentives for efficient activity levels under each liability rule is to identify who is the residual bearer of harm. It is only the residual bearer of harm that has incentives for efficient activity levels. The residual bearer of harm is the person that bears the cost of harm and internalizes it after the parties have undertaken the efficient level of precaution. In the case of simple negligence, the victim is the residual bearer of harm. After both parties undertake the efficient level of precaution, the injurer under simple negligence has escaped liability by meeting the legal standard. For this reason, all liability falls onto the victim. The victim is the residual bearer of harm. The victim is left with the incentive to limit the activity level. Under negligence with a defensive contributory negligence and comparative negligence, the victim was also the residual bearer of harm. Under both of these liability rules, the injurer could escape liability by meeting a legal standard of precaution, regardless of her activity level. For this reason, the injurer would not have incentives to limit her activity level. She would simply have incentives to take precaution. The victim, as the residual bearer of harm, would have incentives for efficient precaution and for efficient activity levels. Under strict liability with a defensive contributory negligence, the victim is able to escape liability by meeting a legal standard of precaution. If it cannot be shown that the victim breached duty, then strict liability with a defensive contributory negligence becomes strict liability. Under strict liability, the injurer is the residual bearer of harm. The injurer has incentives to take precaution and to limit activity levels to an efficient level. So far in our analysis of the social costs of accidents, we have ignored the costs of going to court and adjudicating any disputes. When it comes to these administrative costs, we face trade-offs between strict liability on one hand and simple negligence and the other liability rules that set a legal standard of precaution on the other. Under strict liability, the plaintiff only has to show harm and cause. Under simple negligence and the other liability rules, harm, cause, and breach of duty must be established. So under strict liability, there is less to prove, which can make court cases much simpler and shorter. Under simple negligence, much of the court case may revolve around whether duty was breached, making the trial more complicated and longer. However, since more must be proven under simple negligence, the plaintiff is less likely to bring a suit. The plaintiff will only actually sue if he believes he can establish that the defendant breached duty under negligence. With strict liability, on the other hand, the plaintiff only needs to establish harm and cause, and so is more likely to sue. So with strict liability, we are likely to have more court cases. But when we do have a case, they will be simpler and less expensive under strict liability than under simple negligence. So society faces trade-offs in administrative costs. The fact that simple negligence gives incentives for bilateral precaution creates an appeal for simple negligence on the grounds of efficiency. If we are dealing with something like pedestrians and drivers where both parties can take precaution, then for efficiency we want to use simple negligence or another negligence rule that gives both parties incentives to take precaution. However, if a driver hits a pedestrian and the driver is released from all liability because it was not shown in court that she had failed to meet a legal standard of precaution, the pedestrian is left uncompensated for his losses. How fair is that? The issue here is what liability rule we use determines how the losses will be allocated. Under strict liability, the losses are distributed to the driver regardless of whether he was taking the efficient level of precaution. And from a fairness or even moral perspective, this may make sense because the driver hit the pedestrian, and whether she was taking the efficient level of precaution or not does not change this. A simple negligence rule distributes the losses to the pedestrian in a situation where both parties were taking efficient precaution, and it was the driver that hit the pedestrian. As another example, suppose you let your friend borrow your mountain bike and he brings the bike back damaged. Turns out he went off a drop and the rim of the wheel folded. He claims that he was taking all the normal precaution and that what he was doing was normal mountain biking. Since he had met the legal standard of precaution, he refuses to pay for the bike. You, of course, are not interested in a simple negligence rule. That is, you are not interested in whether your friend met some standard of precaution and was therefore not at fault. All you care about is that your friend damaged your bike. In your mind, establishing harm and cause is enough. And the reason harm and cause is enough is because you think it is unfair for your friend to damage your bike and for you to have to pay for it. You are concerned about the distribution of losses, so you are in favor of a strict liability rule. So there is a moral or ethical case for strict liability. It is the idea that if you break it, you pay for it. Again, the problem with this is efficiency. It only gives one party incentives to take precaution. The moral case for strict liability is that we care at least as much about the distribution of losses as we do about efficiency.